Good morning, Kevin Curtin, Assistant District.
A minute for the clock. Okay, now Mr. Curtin.
Thank you, Your Honor. Kevin Curtin, Assistant District Attorney for Middlesex on behalf of the Commonwealth, and with me is Jim Mulcahy, who was the trial prosecutor and also handled the appeal in the appeals court. Your Honors, Chapman is focused on the verdict and the grounds on which the jury actually rested its verdict in particular cases. And that's why we have the multi-factor approach that we have under the DeGracca tests. We've had it for a long time. It's not exclusive, but they're all available and they're all important. We need them all because every case is different. And there's a big difference, for instance, between an error that strikes at the heart of the defense and one that bears no relation to the premise of the defense. And the premise of the defense factor respects that difference and it should be applicable for judges in particular cases. And it makes no sense not to take away certain of these factors just because we now have got Mendes-Diaz. Even after Mendes, yes.
I'm just wondering this, and I may be remembering incorrectly, but Commonwealth versus Charles was a case in which the argument, I do not think the defendant, as I looked at it, didn't testify, but the argument of his counsel was
that's right.
It was only for personal use, not distribution, right?
That's right.
So the difference here is they actually, or one of them actually testified?
That's right.
They both
That's right.
did.
They both did it. And
so that's what makes the difference?
Well, it's the difference. There are different kinds of things that fall within the premise of the defense. Under Charles, that premise was discernible only through the arguments of counsel. It was non-evidentiary, and the court considered that significant on balance, weighing the other factors. And in that case, the error was not proven to be harmless beyond a reasonable doubt. Here, though, you got a case where people actually took the stand. The defendants testified. That's my cocaine. That's my marijuana. This is how I use it. This is the high that I get off of these substances. There's a lot of other circumstantial evidence that establish strong inference of intent to distribute the marijuana and the cocaine that was found. There was a police officer gave an opinion that it was consistent with. Also, even though this is not in the briefs, in rereading the transcripts, I did notice that there was a dog who came in, and after the drugs were found...
The dog testified?
The dog did not testify.
But he barked.
However,
never mind.
He alerted is the word, but
Alerted.
I don't think that it's a statement of a person. So any hearsay issue with respect to the barking or the alerting of the dog hasn't been raised, and I don't think it would be valid.
Did the I take it the expert who was called by the defense he didn't testify at all about this case or these. He was just testifying generally people who use this much.
That's right.
Versus sell. Is that right?
That's right, Your Honor. And so that's just another kind of evidence that falls within that factor of premise of the defense. And courts should be able to have the flexibility to weigh the kinds of evidence that comes in, because the kinds of evidence that are going to arise in different cases, it's infinite. And there's no reason not to apply these factors. They can be applied in so many different cases. Look at for instance, confrontation errors in having to do with medical examiners' testimonies. It's been very helpful, for instance, to determine that, yes, this error was harmless beyond a reasonable doubt, such as in Pena, cited in the concurrence of Vasquez, or no, it wasn't, as in Durand. Same sort of thing when you're talking about other errors, such as the interference with the right to counsel. It's helpful to determine, yes, this error was was harmless beyond a reasonable doubt, such as in Howard. It's also very helpful to determine, no, it was not harmless beyond a reasonable doubt, such as in McNulty. And the courts have had no problem applying this factor and using it in combination with all the other factors in these Miranda violations, for instance, in the Diaz case, where an improperly admitted post-Miranda denial of guilt came in. That was perfectly able of being weighed together with all the other evidence in the case, and it didn't matter whether it came in after the Commonwealth rested or not, because the appellate court considers the totality of the case, before it. We're not going to retry the case. We're not going to redo a motion for required finding of not guilty. We look at the totality of the evidence before the case.
There was police testimony that the drugs were marijuana and cocaine,
Consistent with.
and there was no objection to that testimony?
There was, I don't believe there was objection to that testimony. I actually didn't reread that. There was an issue initially as to whether the opinion could come in that form. So I don't know the answer to that. I'm very sorry.
You mean, but there wasn't an objection, like, how does
consistent
he
with.
know that it was cocaine, or how does he know that it was?
No, there's no question that this police officer was well qualified and was competent to give the test, to opine that the evidence was consistent with an intent to distribute. And
No.
or
With
consistent
the nature of the drug itself.
Consistent with cocaine, consistent with marijuana. That did come in. I don't think that there was.
Did or did
I don't
not?
recall that there was an objection as to the consistent with. I don't recall that. I'm sorry. that I
But
can't-
was there any objection to the testimony that it was cocaine
That it
or that it
was.
was?
I don't think that there
marijuana?
was evidence that it was cocaine.
It was consistent
I
with
think that the
cocaine, it
evidence-
looked like cocaine, or it looked like
Looked
marijuana?
that's right. It was consistent with and or looked like. And he didn't say this is cocaine.
Is an error harmless beyond a reasonable doubt if the admission of that evidence causes a defendant to testify when he otherwise may not have?
Well, that's. I think that is not necessarily so in every case. There have been cases where an error that would have led to suppression, such as in Charos, could cause that taint to extend so far as to encompass the catch-22 situation that someone like Geraldine Charos was put in that particular case. And that's the best way that I have of understanding that Charos case. And I mean, because there we had police misconduct that should have been deterred and needed to be deterred, and we had the invocation of the exclusionary rule, and under the fruit of the poisonous tree and the attenuation doctrine, there's nothing really to prevent evidence that is not sufficiently remote, or as to which that taint has been dissipated, from being captured.
This is not illegally seized evidence. This is
Not
not
at all.
illegal evidence at all. It just came in through the wrong witness.
That's exactly right. And that's the big difference. That's the big difference here. That's
Now,
the, you know,
what if the evidence would have been insufficient as a matter of law if the certificate had not been admitted? So, but for the confrontation issue, defendant could have moved for a required finding. If he would prevail on that, is there a different result?
I don't think he would have prevailed on that, based on all the circumstantial evidence in the case.
As part of the
consistent
Commonwealth's
with-
case?
As a part of the Commonwealth case, even taking out the improperly admitted evidence and not weighing it together, even if it were viewed in that way, under Dawson and other cases, the judge should have denied the motion for required finding.
Okay, and if the answer is different, would that change the outcome as far as you're concerned?
No, it shouldn't change the outcome as far as the Commonwealth is concerned at all, because it's a different standard. It's a different standard.
So the standard that you employ is simply harmless, not in terms of what a defendant's strategic choices are,
That's
but
right.
purely in terms of whether the evidence whether the elements that the jury is considering would not be affected.
That's right. That's right. I mean, the harmless error standard in defendant's strategic choices when things come in, that is an issue, and it was raised in the reply brief. And, you know, it's something to think about. And you have to think about it and apply the factors to determine how to weigh it. And if you got a case where someone is objecting to evidence coming in, objecting all along, jumping up and down, making a record as to the prejudice here, then the court is in a position to do it. But if you have a situation where nobody cares enough to raise an issue with respect to the composition of the substance or the certificates at that time, it becomes more difficult to do that. And I think that there's a difference.
I mean, what you've just said doesn't seem to square with Charles, does it?
I think it does square with Charles. I think that it's just how you weigh the factors. The fact that a defendant says or makes, as part of an opening statement or a closing argument, say a closing argument, that, all right, this evidence, I'm not going to waste my credibility arguing to you that this was not cocaine. However, the real issue here was intent to distribute. There's something different about that, and the Commonwealth is prepared to recognize that there is a difference, but you weigh it together with all the factors. No one factor is utterly, overwhelmingly controlling. So it depends on how important that evidence is, what is the premise of the defense, and the other factors. So you can certainly have an instance where a defendant, such as in this case, opens to the jury and says, we're going to concede that this is cocaine, that this is marijuana, but it was for his personal use. And the court would still have the ability to weigh that premise of the defense together with the other evidence in the case. The court would not be barred from considering all those factors and should have the flexibility to do that. How it will come out in particular cases is going to depend, will vary from case to case. But there's no reason to say that you can't even consider it. And that seems to be what the defendant is arguing. You shouldn't even consider the premise of the defense simply because it has to do with an element of the Commonwealth's proof. But that's not what we've done in other cases. The cause of death, when we're talking about the medical examiner's testimony, that violates confrontation protections. Commonwealth has to prove cause of death. That doesn't mean you can't determine whether that error is or is not harmless. And I think that that's the principal issue in this case. And for that reason, the Commonwealth submits that the judgments of conviction should be affirmed. Now, there are subsidiary issues that have been briefed.
So before you get to those, is it your view that the standard is different from an exclusionary rule issue from a search than it would be from a confrontation clause? Error.
It has to do, to me, and for the Commonwealth's position is, when you're talking about a Fourth Amendment violation and exclusionary, the invocation of the exclusionary rule, there can be Sixth Amendment violations that result in the suppression of evidence, such as Mavrodakis. But that's tainted evidence. This was not tainted evidence. There was nothing wrong with the prosecutor offering it. There was nothing wrong with the judge admitting it. So the principles that justify suppression on the ground that this is tainted evidence, this was something that never should have happened. She never should have been stopped a mile away from the residence on the basis of a search warrant and then taken back to the residence and for her purse searched for some reason that is not clear in the record of the case, but that is completely illegal. And that needs to be suppressed. And it needs to be deterred. And so the invocation of the exclusionary rule allows for an extension of taint until it is sufficiently dissipated. In that case, she's in the situation, there's $817 in her purse. She's living in the place where the drugs were found. They're in plain view. Obviously, she knew something was going on. So she's got this catch-22 situation. Do I testify and explain the $817? To Geraldine Charos, or do I hope that the jurors, will find me not guilty on the basis of reasonable doubt? But we're dealing with evidence that should have been suppressed. So that is very different. It's a special case, very different.
So is it your view that the fruit of the poisonous tree doctrine does not apply with regard to confrontation clause errors?
Not when it comes to admission of evidence in trial, no. Not in a Melendez-Diaz context, certainly not.
When it's the wrong witness.
Because that's right, because there's nothing to be suppressed. So there's no fruit of there's no poison. There's no poisonous tree.
Obviously, you say this is very different from a sufficiency of the evidence case where you look at the Commonwealth's case.
Yes.
You take the view you should be able to look at everything.
And that's the view that this court has repeatedly taught in the variety of contexts that I've said earlier, the context of confrontation errors in medical examiners and in other recent cases having to do with that are analogous. It's the appropriate thing to do. It's the right thing to do. It's an appellate court. You look at the totality of the evidence before you. Nothing is perfect. Nothing is perfect. Life is not perfect. The law is not perfect. The question, however, is under the Chapman standard, has the Commonwealth established that it was harmless beyond a reasonable doubt? And in a case like this, based on the totality of the evidence, we have. Thank you.
Thank you.
Okay, Attorney De Palma?
Yes. May it please the court, my name is Valerie De Palma, and I represent Ronald Mendes. My co-counsel and I will be sharing our time. I'll be arguing for 10 minutes, and she'll be arguing for 5. I'll start with the Melendez-Diaz issue. The court here should reverse the defendant's convictions because the admission of the 7 certificates of analysis was not harmless beyond a reasonable doubt. In this case, the Commonwealth presented no circumstantial evidence that the substances in question here were, in fact, controlled substances. And this court should not sanction the bootstrap argument that the defendant's testimony rendered that error harmless.
What about the police testimony? I'm sorry.
I'm sorry.
What about the police testimony?
Well, that testimony, the defendant's position is that testimony was entirely conclusory regarding the nature of the substances here. There were
But it's in evidence.
True, but just as in Charles, just as in Vasquez, the police officers never identified the substances as drug identification experts as controlled substances. The 2 officers who executed the warrant both said they were familiar with marijuana. One, in addition, said he was familiar with cocaine, but they consistently referred to the substances as herbal-like substances, white powdery substances. And the the non-percipient police expert witness, Detective Sergeant Montana, who, by the way, was the very same police expert witness in the McDonald case, also did not identify the substances using objective criteria. He was there to rebut the defendant's defense that they were possessors and not distributors of the drugs. He was not there to identify the evidence. In fact, it's probably because the Commonwealth at that time did not think they had to put on any additional evidence besides the certificate.
Was there an objection to the police officer's testimony as to the nature of the drugs, just as to the nature?
No. He testified, there was an objection because his testimony, he was answered a hypothetical based on the facts of the case, which this court has said is okay. But no, there was no objection that he was testifying as a drug identification expert. But he used language that this court has already concluded is not going to be sufficient, or at least for purposes of the harmless beyond a reasonable doubt analysis, is going to be overwhelming, sufficiently overwhelming to overcome the impact of the admission of certificates of analysis. So he said things like, it looks like cocaine, it appears to be. I mean, he, as again, was there to testify that what was recovered was consistent with distribution and not personal use. So in that way, this case is contrasts with McDonald, where this very same officer was called as an identification expert. He did explain his background in identifying drugs. He did identify objective criteria by which he identified the marijuana in that particular case. So I think in this case, we're dealing with no circumstantial evidence to identify the composition of the substances.
But if you add your client's testimony, you've got direct evidence.
Well, our argument is that certainly in considering the factor whether or not the strengths of the Commonwealth's evidence, that my clients and his co-defendant's testimony shouldn't come in there. And respect.
Well, strength of the evidence at trial, which is what we ordinarily look at. We look at the evidence at trial, how the case was tried to determine whether an error was harmless or not. That's our ordinary look.
True. I mean, this court has said it looks at the totality of the case, weighing the tainted versus, or the untainted versus the tainted evidence. And our argument here is that their testimony was tainted.
Well, how is it, oh, you mean your client's
Yes.
testimony was the
Yes.
product of taint?
Yes.
All right, so opening statement, essentially counsel for one of the defendants concedes, my clients had this stuff, but they were, all right. So that happens before there's one piece of evidence in the case. So the Commonwealth could have called the analyst to put the certificates in. They chose not to in this instance. So it wasn't like somehow your strategy was geared to this. I mean, you looked at the case, or trial counsel looked at the case and said, we're essentially dead on the issue of possession. We've got to somehow argue that all of this stuff doesn't equal intent to distribute. And that's the way the case was tried from the beginning to the end, including your client's testimony. So how was that testimony tainted by these certificates?
Because at the time the defendants were tried, the law of Massachusetts was that certificates of analysis come in.
But they were admissible. They were admissible. They just came in through the wrong witness. And I mean, it's not. This isn't evidence that was illegally seized. It never should have been admitted into evidence. Never should have been part of this case.
But I submit, Your Honor, that's a distinction without a difference.
That's an important distinction. It goes to the heart of the difference, doesn't it? I mean, that goes to the heart of what we're talking about, what kind of taint we're talking about. How important is that taint? How does it bear a relationship to everything else that's happened at trial?
Because, Your Honor, I don't think, certainly with reference to the Charles case, this court, yes, that was a Fourth Amendment violation. That evidence should have been suppressed under the Fourth Amendment. But I don't think that this court can extend the exclusionary rule within the context or within the rubric of harmless beyond a reasonable doubt. I think that the question isn't why the evidence was inadmissible. The question is what the impact of the evidence on the trial.
Yeah, the trial.
Right.
Trial
True.
as a whole.
True.
Where your clients testified that it was their cocaine and marijuana.
True, but that decision,
That decision was driven by the fact that certificates were being admitted as opposed to the testimony of the analysts. Your opening statement started with that concession.
True, Your Honor, but in other cases, this court has said that the premise of the defense...
This is more than the premise of the defense. It's the premise of the defense and the defense as actually presented in evidence at trial.
Yes, Your Honor, but I still submit that there's a difference here. And the big difference is that there was a case that identified very specific kind of evidence, certificates of analysis. Unlike a Fourth Amendment, it's not like in the Fourth Amendment we say, these types of boots are always inadmissible or admissible at trial. I mean, it couldn't be done. But the point is, this court in Verde said, certificates of analysis, the admission does not violate the Sixth Amendment right to confrontation, period. And in fact, this court later said, once Mendes came down, in fact, trial counsel did not have to object to their admission because it would have been futile. Our position is that to create symmetry here, the defendant shouldn't be held to waive the argument if they get on the stand to testify.
But in this case, it appears that the defense strategy was, even if the Commonwealth had properly introduced the drug certificates through the analyst, the defense was going to proceed exactly the way it did in this trial. That was the defense.
Maybe,
is that it was for personal use.
Well, certainly this was a search warrant case. It's not as though there were other, I mean, certainly the circumstances of this case, this was the most reasonable defense to raise. However, I believe that speculating how this trial would have gone had the chemists come, speculating how this trial will go if these defendants are retried is just not relevant. In the Coy versus Iowa case, the U.S. Supreme Court said it doesn't matter whether these defendants will, everything will happen exactly the same way. We still analyze this as whether or not the evidence at trial certainly rendered the error harmless beyond a reasonable doubt. I think, again, another thing I see, I'm getting close to the end, that the rationale or objectives of applying the waiver doctrine, because essentially if this court holds that in this case where there is no circumstantial evidence presented by the Commonwealth regarding the substances, we're going to peg this whole thing on the defendant's testimony, is going to amount to a ruling that he waived. And there, in this case, there simply is the rationale and objectives underlying the waiver doctrine are not here. The defendant did not, the trial counsel didn't put them on the stand to waive their constitutional rights. And at the time they testified, the law was verity, and therefore, Your Honor, I see my time is up. This court applies the harmless error rule with restraint. Constitutional error should be presumed, and this court should, based on this error, reverse the defendant's convictions. Thank you.
Thank you.
May it please the court?
Yes.
Excuse me, my name is Pamela Sims-Segre, and I've got the caboose argument this morning. This is the argument about the elephant in the room of most of these kinds of cases, and that is drug request calls that come in and are picked up by an officer either searching pursuant to a search warrant or having arrested or perhaps about to arrest a person, acquires these instrumentalities, these cell phones, and then is allowed to.
Have you joined Mr. Palmer's argument on the other
Oh, I
issues?
do. We join each other's arguments.
Okay,
Indeed,
I didn't see
we
that.
do.
Okay.
I'm glad you let me clarify that. Of course we do. And it's interesting, you know, the court has been emphasizing how the defense attorney in his opening statement, which I found most unfortunate, began a downward spiral of my co-counsel's argument. Co-defendant cases are terribly difficult. Of course, as defense attorneys, we want to sever all defendants from each other because the process, which in its, the trial process, which in itself is subject to conflict and confusion, is even more so in a co-defendant case. And this, in fact, if you look at it from the trial counsel's point of view, was the case here. Mr. Ronald Mendes' attorney didn't help his client's case. But putting that aside, what I'm arguing is that these calls, these drug request calls, which this court has not, I believe, specifically addressed. The cases quoted by the government, Washington and DePina, which allowed these calls, said they weren't hearsay because they weren't being offered for the truth of what they were implying. I would very much disagree with that. They were being offered for the implicit truth of what they were applying. And I would ask the Commonwealth, this court, to adopt the common law approach, which is to say, yes, these such statements are hearsay. They are hearsay. They're made by individuals to the declarant, and they're subject to all kinds of distortions by the witness who's testifying. They are not reliable, and whether or not the person putatively who made the request for the drug intended their statement, their assertion to show that there were drugs at the house is irrelevant because they're still not reliable.
So let's say it was the search here had to do with gaming, and the police are in the house and the call is ringing off the hook. put 10 on, I'll have another or something, and put
You're-
20, and you have call after call after call.
Those
Wouldn't
are-
that be evidence of bookmaking?
Those were old cases, Your Honor. And in this case, particularly since the technology advances as we speak, of cell phone and computer cell phones and multi-purpose gadgets and devices, these are coming in, and the truth is they are hearsay. I would say at the very least, to say yes, these are hearsay, but they're not part of circumstantial evidence, and therefore they should come in, as Judge Agnes analyzed in a case, the Gonzalez case in 2005. They're hearsay, but here are the reasons that transcend the confrontation clause problem here, and let them in. I can't find any reasons that I find persuasive to any exception to the hearsay rule.
But you say they're hearsay, but what's the truth that they're admitted for, except that somebody has made an offer or has made a request for merchandise?
They're admitted for the implied truth that they're asking for drugs, and therefore the defendants are selling them. It's the elephant in the room.
But if that's the case, every offer would be hearsay, even though we generally admit offers, or we admit.
No,
but
not
would that be
every author. In this instance, and because it's such a large part of criminal law at this point, I think it does merit Your Honor's attention to define for the Commonwealth just exactly why you're letting the hearsay in, that it is hearsay. No, of course not. Not all offers are going to generate this kind of response and this kind of effect on the trial process and on the verdict. These are very specific, widely used, and that's the reason why Your Honor should rule on it, because they are so widely used, and they are the big elephants in the room.
Thank you.
Thank you very much.
All right.